I don't think necessarily the offshore workers as a group will be any different from the standard employee, if you want to call them that, because ultimately what the most recent decision, the Bear case, as we're referring to it, Fulton and Bear, is saying is effectively that what you're entitled to is overtime payments. So if you work overtime that's been authorised and that's not effectively being that's being required by your employer, and you're not volunteering in the great scheme of things to do, then ultimately that should be calculated as part of your holiday pay when you go off and leave. So if offshore workers are working overtime, then effectively they should expect that overtime to be calculated in any holiday pay that they receive. But if there's no overtime undertaken, then there's no impact on their holiday pay. So effectively, offshore worker, effectively the same as every other employee in terms of this recent decision. Our legislative changes are a bit thin on the ground at the moment in time, and that's probably because of the upcoming general election in 2015. So one of the things to come about is the fitness for work referral system, which is coming into effect in May of 2015, whereby if an employee is off for more than 4 weeks, 4 weeks being the trigger point, then the employer can refer the employee to this free government service for an assessment. Now, it sounds very grand, but effectively it's a free service. And as I understand it, the way that's to work is effectively by remote consultation, so by email, Skype, and a report will then be produced by the occupational expert following these remote consultations. So its effectiveness is to be yet to be seen. It's a good idea in theory to try and get people back to work sooner rather than later. But I would suggest to any employer, irrespective of this scheme coming in May, that they should be robustly managing absence in any event, looking to get GP reports and occupational health reports externally to this anyway. That's really all that's on the immediate horizon for 2015, save for the general election, where various parties are likely to tinker with employment law, and the various party political persuasions will be seen in that legislation. For example, I think the Labour Party will look to remove or reduce, more to the point, tribunal fees to make them less draconian, or to increase access to justice as a social policy, whereas the Conservative government, that they're likely to probably keep fees where they are at the moment in time as an income generator. Another area that's likely to be up for debate, of course, is the hot topic of 0 hours contracts. That there is a plan by October 2015 to have abolished what's called exclusivity clauses, whereby employees who sign up to a 0 hours contract usually are not allowed to work for another employer on a 0 hours contract, even though they're not guaranteed any hours by the first employer, which is seen as being morally reprehensible by most politicians and political parties. So therefore, there'll be some changes there as well. Again, I think there'll be more changes if there was to be a Labour government than a Conservative government, but again, they're still consulting on those at the moment in time, so we'll just have to wait and see. Well, it's very interesting because a lot, not all, but a lot of our employment legislation comes from Europe, or has its birth in Europe, predominantly equality legislation. So it'd be interesting to see if a removal from the European Union means that we just put all that to one side. Can we? We probably can, not without a lot of work in terms of repealing laws and introducing new laws. If there was to be new laws introduced, there might be no change. That we might take the best that Europe's given us and actually carry that on in maybe a revised format, or in the same format. Also some more subtle differences. The working time directive, that's a European piece of legislation which obviously regulates holidays, regulates holiday pay, regulates working time. And again, if we were to step away from Europe, do we keep this? Do we change it in some way? If we do change it, how do we change it? What will replace it, if anything? is that is a removal from the European Union and the safeguards that arguably this European law gives us, is this likely to be open to abuse by a political party that becomes government? These are all things that we need to wait and see if and when that time comes.